Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. Extrinsic similarity is shown when two works have a similarity of ideas and expression as measured by external objective criteria. To make this determination, you must consider the elements of each of the works and decide if they are substantially similar. This is not the same as identical. There has been testimony and evidence presented by both sides on this issue, including by expert witnesses as to such matters as A, for got to give it up and blurred lines, and B for after the dance and love after war, the chorus vocal melody and chords. The gay parties do not have to show that each of these individual elements is substantially similar, but rather that there is enough similarity between a work of the gay parties and an allegedly infringing work of the thick parties to comprise a substantial amount. Intrinsic similarity is shown if an ordinary reasonable listener would conclude that the total concept and feel of the gay party's work and the thick party's work are substantially similar. In considering whether extrinsic or intrinsic similarities are substantial, you may consider whether portions allegedly copied are either qualitatively or quantitatively important to either of the gay parties' works. A portion of a work is qualitatively important if, regardless of its size, it is shown to be very important to that work. The copying of a qualitatively important portion of a work may support a finding of substantial similarity even if that portion is very short. A portion of a work is quantitatively important if it comprises a significant portion of the work. If you find that the gay parties meet their burden to show that there is substantial similarity between either or both pairs of the gay party's work and the thick party's work, then there is a presumption of copying by the thick parties. The thick parties may rebut this presumption if they show by a preponderance of the evidence that they independently created the allegedly infringing work or works. In determining whether the thick parties have met their burden of proof, you may consider, among other things, evidence concerning the manner in which they created their works. All right, that is the end of that jury charge. So for now, let's try some closing argument. Ready? Here we go. Maybe the driver wasn't paying attention. Maybe the driver drifted over a little bit. Maybe he'd been working a long time and wasn't as alert as he had hoped to be. Maybe he decreased his speed. We don't know how that tractor trailer got there, and you know what? Neither does the guy driving the tractor trailer. But what Mr. Irvin does know is that he knows what he did, and he knows that he went over right into this lane as soon as he was able to. His speed remained constant at 35 or 40 miles an hour, and that's consistent with what Ms. Young said. She said she was going 35 or 40 miles an hour and that she had been in the back, along this time. There's nothing inconsistent about Mr. Irvin's version of this accident. And when you look at how the defense had asked for you to speculate as to what Mr. Irvin may have done that could have resulted in this situation, I'm not asking you to speculate about what somebody did. I'm asking you to use the evidence that was given to you by the only eyewitness to the accident as to what happened. And it's not unsupported evidence. It's not Mr. Irvin just saying that this is what happened. Ms. Young, she said that she never saw this car, this tractor trailer before the accident. And Mr. Stevenson asked you to think, well, okay, she would have had, she said, he even quoted her testimony that she said she would have had to, you would think she would have seen something as big as that. You would think somebody would see something as big as that. But you know what else? It isn't unusual for Ms. Young not to be able to tell you exactly where the vehicle was, because what else didn't she see? She didn't see the white Honda either, which would have been right next to the big truck she didn't see. Her testimony is that she didn't see the tractor trailer and she didn't see the Honda, but what she was emphatic about is that the first thing that was said to her is, did you see the truck that cut me off? And that at the scene she saw the truck after the accident, that it was up by the light. So far what we have here is the defense is asking you to speculate as to what Mr. Irvin may have done that could have resulted in this situation. Mr. Irvin isn't asking you to speculate. He told you what he did, and he told you what the tractor trailer did. Now he couldn't tell you how it is that the tractor trailer got into the position next to his car, that it was because he wasn't driving the tractor trailer. So he can't tell you whether the driver of that vehicle braked or whether he did anything else other than what he did tell you that the driver of that vehicle did. That the vehicle came into his lane and that in order for him to get away from it, he had to swerve. Now, one of the great things about having common sense is that it cuts both ways, just like everything else does. And you do bring your common experience to this courtroom. And when I look at this diagram, what I see, what I think, is what most likely happened. If I think that most likely these vehicles came in a position somehow where Mr. Irvin was in this tractor trailer's blind spot. And I think the tractor trailer never saw him. I think the tractor trailer started to come into his lane. And I think because Mr. Irvin was alert enough to swerve away from it and have it not contact him, I think the tractor trailer kept on going and never realized what the heck happened because he was in the blind spot and he just kept on trucking right down the road. Now, that's what most likely happened in this case, is that Mr. Irvin had to react quickly in a dangerous situation, and he reacted appropriately as a reasonable person would by taking the most immediate route away from the danger. He testified that he didn't see Ms. Young was there. Of course he didn't. He didn't have time. But it was a split-second decision that he had to make. Because of that, I'm going to ask that you view the negligence of the tractor-trailer driver in the light that it should be viewed in. You have primary direct evidence as to what happened. It's supported by Ms. Young's comments that is exactly what he said at the scene. You should answer the question pertaining to Baltimore Tank Lines, that one. The Baltimore Tank Lines vehicle was negligent, and 2, that negligence was the cause of the accident. You should evaluate what Mr. Irvin did as you're required to under the law through the light of the situation. He was in a clear and present serious danger right there to him. He did what a reasonable person would do in trying to get away from it. And we can't Monday morning quarterback what he did from our comfortable position in the courtroom. Also, he doesn't have the burden to show that he didn't do something negligent. The defense has the burden to show that he did, and you've heard no evidence that he did anything negligent. Thank you, ladies and gentlemen. All right, now for some literary practice. Let's see what we have. This is called a valued vacation. Ready? Here we go. It was a basement room, barely big enough to hold a double bed, in a small bed and breakfast inn near London's Victoria Station. A narrow slit at the top served as a window. Although the accommodation was modest, the housekeeping was immaculate, and the rate, at that time, about $70, included a hot breakfast of bacon, sausage, beans, toast, and eggs cooked perfectly sunny side up. On Paul's first visit to England, we didn't have much money because it was early in our careers. We walked everywhere, Elizabeth showing Paul her favorite London haunts from previous visits: Camden Town's outdoor markets, Primrose Hill's scenic vista, and Hyde Park's Rotten Row. We ate in neighborhood tea shops and a favorite vegetarian Indian restaurant. We didn't spend a lot, but we had a memorable time. We appreciate the care and attention to detail that go into luxury travel experiences, but some of our happiest trips have been humble ones. We love state parks, many of which are free, and when you're traveling with family or in a group, that can really stretch the budget. One autumn in Indiana, we visited Spring Mill State Park with Elizabeth's family. Trees in shades of gold and red provided the backdrop for a restored pioneer village dating to 1814. "I love the woods," said Elizabeth's sister, Cynthia, as we sat down to lunch at the Spring Mill Inn and feasted on hearty Hoosier fare, such as fried chicken, green beans cooked with bacon and onions, and cornmeal pie, all for a mere $8.99 a person. Needing a respite from our 24/7 schedule, we signed onto a 4-night Baja Mexico cruise out of Long Beach on Carnival Cruise Line's Carnival Inspiration. The ship isn't upscale, but the multi-deck atrium with lighting that constantly changes color and the whimsical Joe Farkas designed interiors, such as a violin bar with motifs evocative of the instrument, delighted us. When we walked out on deck and gazed at the ocean, work pressures dissolved, all for way less than $100 a night each. Years of travel have taught us that it's the experience, not the price tag, that makes for a valuable vacation. All right, let's try some jury charge. Ready? Here we go. If during the trial you have a question that you believe should be asked of a witness, you may write out the question and send it to me through my courtroom staff. I will share your question with the attorneys and decide whether it may be asked. Do not feel disappointed if your question is not asked. Your question may not be asked for a variety of reasons. For example, the question may call for an answer that is not allowed for legal reasons. Also, you should not try to guess the reason why a question is not asked or speculate about what the answer might have been, because the decision whether to allow the question is mine alone. Do not hold it against any of the attorneys or their clients if your question is not asked. Remember that you are not an advocate for one side or the other. Each of you is an impartial judge of the facts. Your questions should be posed in as neutral a fashion as possible. Do not discuss any question asked by any juror with any other juror until after deliberations begin. Each one of us has biases about or certain perceptions or stereotypes of other people. We may be aware of some of our biases, though we may not share them with others. We may not be fully aware of some of our other biases. Our biases often affect how we act, favorably or unfavorably, towards someone. Bias can affect our thoughts, how we remember, how we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make very important decisions in this case. You must not let bias, prejudice, or public opinion influence your decision. Your verdict must be based solely on the evidence presented. You must carefully evaluate the evidence and resist any urge to reach a verdict that is influenced by bias for or against any party or witness. From time to time during the trial, it may become necessary for me to talk with the attorneys out of the hearing of the jury, either by having a conference at the bench when the jury is present in the courtroom, or by calling a recess to discuss matters outside of your presence. The purpose of these conferences is not to keep relevant information from you, but to decide how certain evidence is to be treated under the rules of evidence. Do not be concerned about our discussions or try to guess what is being said. I may not always grant an attorney's request for a conference. Do not consider my granting or denying a request for a conference as any indication of my opinion of the case or of my view of the evidence. All right, we will stop there. That will conclude our literary and jury charge practice.